All right. The next case before the court will be Jonathan Smith versus State.
Good morning, may it please the court. My name is William Pinnell, and I represent the appellant Jonathan Smith in this case. Please reserve 5 minutes of my time for rebuttal and excuse my voice. In this case, Mr. Smith was found guilty on count 1 but acquitted on counts 2 and 3 of the amended information. Importantly, there's no forensic evidence, forensic, scientific, or eyewitness testimony corroborating the allegations made against Mr. Smith in this case. As noted in our briefs, it's our position that the trial court committed 4 separate errors in this case. We believe both individually and cumulatively that they require a reversal of Mr. Smith's remaining conviction. Because we're limited time, I'm going to focus on issues 2 and 4 of the briefs. Certainly answer any questions the court has about the other claims. So initially, it's our position that the trial court erred by not redacting the audio recording of Mr. Smith's interview with the police.
And that actually is going to take some time. I just wanted to briefly, before you start there, you alleged that he had invoked or asked a question of the detective, do I need a lawyer, and that there was misadvice given. Where the investigator says, no, doesn't just say no, he says no 3 times. But what do we do with what follows directly after that, where your client says, no, I'm just joking, man?
I think from listening to the recording and a fair inference from that statement is that Mr. Smith is nervous and under the gun, and he has two police officers coming into his house to ask him questions. So I don't believe that undermines the question or absolves the officers from properly answering the question, which is the proper answer and the honest answer is it's always up to you whether you need a lawyer, not you don't need a lawyer. So it's misleading, and I don't think the subsequent statement undermines the question.
Now, why doesn't it? I mean, isn't that conclusory on your part that it doesn't?
Again, I think it's a fair inference that after hearing what the police told them, that the defendant was nervous by being approached by 2 officers. So,
and do you think that obligation extends? And I understand your position that this was custodial interrogation, but if this court found it was non-custodial, do you think that obligation extends to non-custodial interrogation?
I don't see anything in the cases that talk about that requiring a proper advice that says that it has to be a custodial interrogation. So I think that the officers always have an obligation to give an honest and clear answer or respond with clarity, and they certainly shouldn't misadvise an individual they're seeking to question about a serious crime. So I haven't seen any cases that specifically address that issue. I think the only appropriate answer is it's up to you, Mr. Smith, whether you want a lawyer at this time.
And in terms of an obligation, doesn't that arise out of the coercive nature of custodial interrogations? So if he is truly there in a voluntary capacity, those dangers that he would be coerced aren't present, and therefore a legal obligation to inform of a right to an attorney wouldn't be present.
Certainly they have no. If he's not in custody, they have no obligation to read him full Miranda warnings. I think it may be different now if you have a direct question from an individual. I would agree that the custody issue certainly applies to whether they have to give him the full range of Miranda warnings. I think it's different, and at least the cases don't say specifically that where there's not custody, or where maybe there's not custody, they don't have an obligation to give a clear and direct answer and to mislead him when they know they're going there to try to get a confession on serious charges. So it is our position that...
Go on then.
Okay.
Into the redaction.
So it's our position that the trial court, on specific objection of trial counsel, should have redacted additional portions of the audio recording of Mr. Smith's...
The trial counsel or the judge?
Trial counsel objected, and the judge should have redacted the video or ordered the redaction of the video. There's a long line of cases that say portions of an audio or a videotaped interrogation of a defendant by police that include the personal narrative of an officer about what the officer believes the true facts to be, or the officer's personal opinion of the defendant's guilt, or the officer's personal opinion about a witness's credibility needs to be redacted. And that starts with the Jackson case from the Florida Supreme Court in 2012. And in that...
In terms of harmless error, some of the comments, basically, why else would a 6-year-old say something like this? What justification, if this didn't happen, why else would she say this? So when you look at harmless error and closing arguments, a lot of those comments are made by the prosecutor without objection. So can you address how we would find this as reversible error in light of that entire theme permeating closing argument without objection?
Well, first of all, I think closing argument is different than testimony, and I think that the Florida Supreme Court has said it's especially harmful. Well, let's back up. Closing argument is, quote, argument. Testimony is supposed to be witnessed fact testimony. Argument is when argument's supposed to be made, and the Supreme Court has said that when a police officer is able to say it, that it's especially harmful. So we have that, because jurors are likely to believe police officers when they give opinion testimony. It's different when a lawyer says in closing that the evidence shows that the alleged victim was credible, as opposed to the officer giving his personal opinion. Those are distinctive, and the danger is much higher when you're in the non-argument section of the trial and there's a decorated detective or an experienced detective giving that testimony.
And that might be, but we're looking at a transcript or audio recording of an interrogation.
Sure.
Don't you think jurors can appreciate the difference between tactics used in an interrogation and witness testimony, somebody sitting on the stand and saying, I believe that this is my view?
I don't, Your Honor. I'd cite the Posh case from the Second DCA, where it says that a jury cannot be expected to understand which parts are appropriate and which parts are inappropriate. And I point out to the court that, and the court knows, the harmless error standard is a high standard. They have to prove beyond a reasonable doubt that the improper statements did not contribute to the verdict on count 1. Importantly in this case, and this goes to the harmless error, the jury specifically asked to hear the interview again during deliberations.
What case were you citing?
Posh, P-A-U-S-C-H.
Is that in your brief?
It is.
Oh, yeah, Posh versus State, okay.
So are you saying that the officer's testimony was almost akin to expert testimony, expert opinion testimony, and that's what made it or elevated it to the error, fundamental error?
Well, I don't think it's fundamental error. I think it's preserved. So harmful error. So I think it could be characterized as expert testimony because the officer repeatedly says no 6-year-old would know this, no 6-year-old would be able to come up with this.
How many times did he say that during the course of this interview?
Numerous times. I don't have a number, but what I think those statements are improper. But I think the more improper statements, the more egregious statements are. Investigator Toredo saying, I can tell you once again from experience, it's in her brain because, quote, because it happened. His personal opinion, it happened. I'm going to tell you right now, I believe that your daughter licked someone's pee-pee. I wholeheartedly believe that 100% that she licked someone's pee-pee. That's a personal opinion on her credibility. The only evidence on count 1 is her statements, her testimony.
Do you think that there's a difference between what might be a proper investigatory technique and what then should be admitted to a jury?
Of course.
So that the police might be fine to go ahead and use those techniques in interview, but in interviewing a suspect, but it shouldn't be admitted in trial.
That's why we have the trial judge as the gatekeeper to protect the rights of the defendant. So it may be that the detectives didn't do anything wrong during their interrogation to try to get to the truth, but it's not, the courts, starting with the Florida Supreme Court in Jackson, said that redactions are appropriate in certain circumstances.
The fact is that the judge in this case didn't redact anything until until the police went clearly overboard after he said, "I'm done," and they kept questioning him. That got redacted, but before that, nothing got redacted.
Correct, Your Honor. Correct, Your Honor. There's countless times where the officer testifies or gives statements that a 6-year-old couldn't come up with this. Multiple times where the officer specifically said, "She's not lying. I believe her 100%." And in none of those occasions on the statements that we cite in our briefs is there a relevant response or admission from the defendant. So it's not important for the context. It's not important to show a relevant response, which we acknowledge would be appropriate if they asked a question and then he said, "I did it, everything you said is right," then it would come in. But over and over again, Mr. Smith denied this occurring in response to these statements.
And I think the state argues part of this in the brief. I know you'll have a chance for rebuttal, but how would you address the argument that, one, your client never admitted to anything during the interrogation, and it seems like the jury at least believed portions of that, as evident from the verdicts with the shower incidents. And second, even with that in mind, the primary focus of the trial was the victim's testimony.
Well, the problem is, you're right, the primary focus was the victim's testimony, and the problem with the statements that were improperly admitted is they bolster her credibility. So the case is about her credibility because the only evidence supporting the conviction on count 1 are the statements of the alleged victim. So right here, there's no corroboration. So this is the textbook case where you should not be able to improperly bolster the credibility of an alleged victim, and it happened over and over and over again during this interview. And during closing, the interview was cited by the state throughout. They specifically referenced the television in the bedroom as evidence that the alleged victim was being truthful. That's from the interview where the defendant admitted there was a television in the bedroom. And they asked to hear the interview again during the deliberations. So they focused on this interview during the deliberations, the unredacted version of this interview, to the detriment of Mr. Smith. So the state cannot meet its burden of showing proof beyond a reasonable doubt that the outcome was not affected on count 1.
On retrial, since he was acquitted on counts 2 and 3, would there be any relevancy to anything in that recorded statement?
I don't believe so, Your Honor. I think the recorded statement, other than some discussion about the bedroom, about whether there was a TV in there, I think all the other stuff on the recording has to do with incidents that allegedly occurred in the shower. And count 1 has to do with an incident that allegedly occurred in the bedroom.
Right, I understand.
So it's our position that based on Jackson and the progeny from the Jackson case, that reversal is required on count 1 based on the trial court's failure to redact the interview of Mr. Smith. Additionally, during closing argument, the prosecutor improperly commented on Mr. Wright's right to remain silent and shifted the burden of proof to the defense. During closing arguments, when referencing Mr. Smith's reaction,
Position that the curative instruction wasn't sufficient to.
I don't think it was sufficient, Your Honor.
And why not?
And so the curative instruction tells the jury that, quote, "The burden of proof is on the state. The defendant is not required to disprove anything or prove his innocence." That admonition only has to do with what happens at trial. They're never told that Mr. Smith has a right to remain silent both before and during trial. And that's what we're talking about. They're talking about what he did not say before trial.
But that was the instruction that the defense requested. I mean, when they asked for a curative instruction, that was the portion of the jury instructions that they requested be read.
Well, I want to break it down into two parts. I think the mistrial should have been granted, and I think that's the error here. I think that you can't unring that bell. It's a blatant statement that's analogous to the Lenz case, where they say, and sometimes silence can be deafening. It's analogous to the Lowry case where the victim's mother called the defendant and he didn't say anything. At that point, the judge, if you read the record, I don't think is convinced that anything inappropriate happened, and it's clear something inappropriate happened under the case law.
If a defendant makes a statement, and as your client did, and there are things that he doesn't say, isn't that fair game to comment upon the substance of what was and wasn't said?
I don't think so, Your Honor. I'd cite this court's decision from Morris, where they said that at the time of the arrest, the defendant didn't say, I haven't been drinking, why are you arresting me? And they said that was improper. That was an opinion by now Justice Lawson and joined by yourself. I think you can contrast, I think you could certainly argue, and the prosecutor did in another part of closing, that he said he was sorry, and why was he saying he was sorry if he didn't do anything? I think that's fair argument. What's not fair argument is to say there's admissions by silence. That's telling the jury he has some obligation to give an exculpatory statement. And this court in Morris, the court in Lowry, and other courts cited in the briefs have said that that's not true. The defendant has no burden to give an exculpatory statement either before or during the trial. And that was highlighted for the jury in this case, and it was improper, and it's reversible pursuant to this court's decision in Morris. I reserve the rest of my time for rebuttal.
All right, thank you, sir.
May it please the court, I'm Carmen Corrente, representing the state of Florida.
Mr. Carrington, do you
Yes.
agree with my earlier assertion that you can have a valid law enforcement technique used during the course of interrogation and yet it's not admissible into evidence?
Yes. It would,
So
of course, depend
if-
on the
if,
circumstances.
Let's say an investigator were to say numerous times, over and over and over again, 6-year-olds don't lie. Is that a fact in evidence?
It's not a fact, no.
All right, so it's either an opinion or it's argumentative, correct?
It's an interrogative technique.
That's fine, but the substance of it is either an opinion or it's an argument, right?
I'd say it's a technique, Your Honor.
No,
It doesn't have to be
I
a
understand.
6-year-old.
I'm not arguing, I'm not discussing with you whether it's a technique. I want you to answer the question that I'm asking you. It's not a fact, therefore it's either an opinion or it's an argument.
Why isn't it a suggestion, Your Honor, that someone else did this, that someone else couldn't have made this up?
Are you going to answer the question or not? Or should I just move on figuring that you're not going to answer the question?
Well, Your Honor, I think you're limiting me to two alternatives which don't apply to that question, but if
All right, well,
I
what
had
is
to
it?
make
If
a
it- if
choice,
is an
I would say it's
investigative
it would be an
technique
argument.
admissible in evidence?
Not necessarily, but not repetitively perhaps as in this case, but it is an admissible technique because
Well,
they are...
Why is it an admissible technique?
Because you are
Why is the-
confronting-
Why is the fact that I believe the victim, because the victim doesn't lie. That's effectively what the police officer is saying, is that this victim's not lying. These people, 6-year-olds don't lie. This victim's not lying. Why is that admissible? It might be a valid technique that law enforcement can use during the interrogation, but it's not admissible in evidence to bolster the credibility of the victim.
But you're also trying to ask the defendant, why is it that somebody would make up this story about you?
Well, you could ask that very question without saying they don't lie.
You could.
Okay, but they didn't do it that way.
They did not.
Okay, and that all came into evidence, even though, the defendant filed, 2 pages with, I haven't counted them up, but they're between, 30 and 50 specific instances that were requested to be redacted, and this trial judge redacted 0.
Well, but if you look at the state's response, they agreed to redacting on their own without the judge having to intercede. A lot of that was redacted. The 6-year-old was redacted more than once, I believe. It was limited. But don't forget that we're talking
And then wasn't it argued in closing argument? Is that correct?
It was. I mean, it was argued in closing argument, the statement and how the defendant answered questions.
So it did turn into argument. In answer to Judge Cohen's initial question, it ultimately turned into an argument, the state's argument.
Well, the
That
state's
six-year-olds don't lie, correct?
well,
Bolstered the testimony, arguably raised it, according to Mr. Pennell, to the level of expert testimony, and then reiterated and argued the testimony to the jury in closing argument when there was no way to rebut or challenge it at that point. Is that correct?
that's not my memory of the closing argument, Your Honor. They talked about the statement and talked about how he reacted in the statement, but then the only thing I remember is not necessarily the 6-year-old, but how would she make this up? Why would she make this up? That's a valid
Was the phrase
question.
six-year-old used in closing argument?
I think it may have been used just once, but I
Why?
don't remember it being repeated.
Why was it used?
Pardon me?
Why? What was the point to that?
Well, the point was
I mean,
that
the jury, you
this-
could have said, remember the testimony of, you could have named the victim.
You could have.
You didn't have to
Let's-
use the phrase six-year-old.
All right, well, let's back up. This was an autistic child. This was a child who shouldn't have known many of the things an adult would know.
That's what the state says in every one of these cases. It's not whether the child's autistic or not autistic. In
They
every
say
one
a
of these
child of
cases-
tender years who doesn't know these things would have had to learn them from someplace else.
Just to clarify, is it your position that there was no error in the admission of any of these statements that were requested to be redacted?
Okay, of the police officer, I think that at the end, there was a lot of that which related really only to the portions he was acquitted of.
So your
There
position
was-
is only after he says, "I'm done," and then goes through that?
After that point, it may have been appropriate for the judge to have excluded that, but that was harmless.
So my next question, let's say we're just sitting in trial, and a police officer walks in, sits on the stand, and says, "I don't think 6-year-olds would lie about something like this." Objection sustained, every day, right?
Yes.
So if that testimony comes in through an interrogation that the jury can hear, aren't we basically creating a special evidentiary exception for interrogations and transcripts of interrogations?
No, we
That's not
have,
in the evidence code.
but we have a defense attorney who objected to certain portions. We have the state who removed some of that. And then we don't have any objections afterward. We don't have anything to say, we need to take this part out. This part is not part.
Filed a 3-page motion.
Well, we have the motion and we have the state's response. And the judge then at trial went through the rest of them, the ones the state didn't redact, and made rulings. But those pages, if you were to take them all out, it's still harmless error because
But
there was
Judge
100
Sasso
pages of
asked you
his
whether it
statement.
was error, and I don't even know that you're conceding that.
No, I'm not necessarily conceding that it was error, but if it was harmless. There was 100 pages of testimony here.
You don't think
He
it was
denied
error?
it every step of the way.
You don't think that commenting upon the credibility of the victim is error?
Taken as it was, I would not have.
Being taken as it was. I
Well,
have no idea what that
okay,
means.
this was an officer who was trying to get the defendant.
That's fine, but that's an investigatory technique, and that's fine, except you don't put it in front of a jury.
The officer was asked if he had any other evidence against him, if this was not just an investigatory technique that he was using, and he did tell the jury that. So I think the jury was well aware that they were pushing him, and he didn't budge, not on count one.
Right.
And the rest of it,
Prosecutor, all right, let's move on.
Okay.
And the prosecutor argued that the defendant had to explain how a 6-year-old could come up with these allegations. Does that shift the burden of proof?
well, are we, when you say we moved on, you're still talking about the 6-year-old?
I'm talking about the closing argument of the prosecutor. They argued that it was up to the defendant to explain how a 6-year-old could come up with allegations, with
Well,
these
there should have been,
allegations.
that perhaps should have been objected to. I don't believe it was. It's not fundamental error because it's a question you could ask the jury if you just phrased it differently. How could a 6-year-old come up with that? That was one of the points of the state's case. It couldn't have learned it from anyone else. And then that's a very telling point.
Well, that's the argument, and that's the scary thing of these cases.
Yeah.
Is that that's the argument that the state makes in every one of those cases. It was the case before this, it's this case, it's almost every one of these cases. That's the argument that the state makes, and you know, you had no physical evidence in the case, and then you've got all these issues with the comments upon the credibility of the victim.
But again, the state would remark that he denied on that statement and those comments, just, he denied everything.
Do you know how many times that the detective said 6-year-olds don't make these allegations up? How many times during that interview?
No, but am I going to find out? Do you know? No.
I'm just asking.
No, okay, no. I don't know the number, but it was more than 1 or 2 times, yes. Again, though, my understanding is the judge redacted the 6-year-old comment. I think that was in an order. But it still came out. There was no objection.
I can tell you that she's not lying about this. That's another, you know, is that proper?
It would have been better if that wasn't there. That sounds like an opinion. Yes, it would have been better, but it's not reversible fundamental error.
If we disagree with you on, you know, whether it was error, can you just quickly best argument on why it'd be harmless?
All right. 2, you mean for the statement itself? We're talking about the statement. He was able to testify without cross-examination. He explained exactly in that statement why he said he was sorry. He gave the jury information. He denied it all the way through so that he was never compromised in any way, and he was certain on that. And the comments at the end were comments on the shower incident for which he was acquitted. There was no overlap between the two. And that's the state's best argument on why this is harmless.
So you've got the admission of these various statements, you've got the shifting of the burden of proof, you've got the comment upon the defendant's right to remain silent, and you think that that constitutes a fair trial?
I do, Your Honor. In the overall scope of the trial, I think, yes, there was appropriate evidence from the victim, from the mother. He denied everything that he had to say. He said, I didn't do it. We had a child who was autistic, so we had someone who wouldn't have known these kinds of things. And I think that the jury was not, they didn't convict him on the shower incident, so they weren't fully on board with whatever inflammatory comments or statements that were made. They found him guilty on one thing. What they believed was the child and the child's mother who testified
The
as to
child's
what
mother
happened.
had no independent knowledge. All the child's mother did was to repeat the allegations that the child made.
Correct,
So let's
but the
be-
state limited
so
that.
let's be
There
very
were-
clear about it, that it still comes down to the credibility of the victim versus the credibility of the
But
defendant.
the credibility of the victim, given the mother's testimony as to the circumstances surrounding it, is undeniable. There were 3 witnesses against this defendant, just the child, the mother, and the deputy. And the evidence is
Did the mother
clear.
have any independent knowledge that, of the incident?
No, there wasn't. But that happens also often in these kinds of cases. That's child hearsay. That's
I
what
understand, but you're
lets
the
the
one
child
saying, well,
hearsay
there were
in.
3 witnesses, you know, and I'm suggesting to you that when it really comes down to it, there's 1 witness.
Well, but there were more things the state could have done and they didn't. The CPT interview, the nurse that overheard that or saw that, none
So
of
you
that
just
was
keep
introduced.
repeating it over and over
It
and
would be
over.
just repeating it over and over, but that wasn't done in this case. This was simply the state put on the case. You listen to the child, you listen to the mother, you listen to how the defendant answered, how he spoke, you make your decision. I think that was a fair trial.
Right.
There's no other questions. I ask you to affirm.
All right, thank you, sir.
May it please the court. The only evidence on count one was the alleged victim's testimony. Her credibility was improperly bolstered over and over and over again during the interview that wasn't redacted. The state cannot prove that this was harmless error. Reversal is required. If the court has no other questions, I would rely on my initial argument and my briefs.
Thank you, sir.
Thank you.